Hello friends, today in this session we are going to discuss the case Union of India versus Shri Ram Bohra and others. First, let us briefly understand this case. The Union of India filed an appeal in a suit against Shri Ram Bohra and others where damages of rupees 18,448 were claimed due to the non-delivery of 11 bundles of cloth on time. The trial court issued a decree in favor of the plaintiffs on August 29, 1951. Later, in the High Court, the union's appeal was dismissed because, based on the representation of the joint in the family, the benefit of the appeal accrued solely to the joint family. The Supreme Court, reviewing the appeal under Article 188, held that if the property of the joint Hindu family is undivided, then once the appeal against the deceased successor is terminated, an appeal cannot be maintained against the other heirs. Therefore, the Union of India's appeal was dismissed along with cost. Now let us study this case in details. Answer: Union of India Plaintiffs versus Shri Ram Bohra and others defendants. Reference AIR 1965 SC 1531. Issue: whether the mortgage placed by a father to discharge a previous debt in binding on his minor sons. Facts of the suit: Mr. Vilas Ram Bohra, son of Mr. Bansidas Bohra, and Shri Ram Bohra, son of Mr. Dhanpati Ram Bohra, filed a suit against the Union of India claiming damages of rupees 18,448 due to the non-delivery of 11 bundles of cloth on time. These bundles were sent on October 20, 1948 by Messrs. Ramkishandas Sagarmal, Bombay, in the name of Messrs. Banshidhar Ganpatiraya. The plaint states in its first paragraph that the plaintiffs were engaged in the trade of cloth and other goods, and their firm was named Messrs. Banshidhar Ganpatiraya, a joint trading firm operating under the Mitakshara branch of Hindula. Being the promoters and representatives of this firm, as well as the heads and representatives of the joint family, the plaintiffs instituted this suit. Trial court. After considering the suit, the trial court issued a decree in favor of plaintiffs on August 29, 1951, directing that the suit be decreed along with costs and that the defendants pay rupees 18,448 with interest. Consequently, the Union of India lost in the trial court and decided to appeal in the High Court. High Court. Union of India filed a prayer and appeal before the High Court seeking to get aside the trial court's decree and to have the suit dismissed along with costs. The plaintiffs served notice of this appeal on the defendants in the suit. It was noted that Vilas Ram Bohra had died on July 24, 1957. On September 5, 1958, the Union of India submitted a prayer under the Code of Civil Procedure, Order 22 Rule 4 and Order 22 Rule 11, requesting that with condonation for delay, the decree be set aside. However, on December 1, 1958, the High Court dismissed the application, holding that condonation for delay was not possible in view of the fact that the names of Vilas Ram Bohra's representatives were known well in advance. Despite the union's lawyer receiving notice of this suit on May 16, 1958, negligence prevailed and the High Court, not satisfied with the facts presented by the union, dismissed this appeal. The High Court further observed that if it were assumed that both plaintiffs had filed the suit as heads of a joint Hindu family, then the termination of the appeal against the deceased successor would benefit the joint family, since the appeal had been passed in favor of Vilas Ram Bohra's representatives, whose appeal could not be set aside due to his death, and he was associated with the joint Hindu family. The appeal could not be maintained against the other head, Shri Ram Bohra. On that basis, the High Court ultimately dismissed the appeal. Supreme Court. Union of India under Article 188 sought leave to appeal before the Supreme Court. A key issue considered by the Supreme Court was whether an appeal could be maintained against the successor Shri Ram Bohra, successor number 2, when the appeal against successor number 1, Vilas Ram Bohra, had already terminated, given that the names of the heirs and legal representatives were recorded very late. Supreme Court held that if the right of succession in a joint family is undivided, then once the appeal against the deceased successor is terminated, an appeal cannot be maintained against any other successor. Since the decree was passed in favor of the joint family, its benefit would accrue solely to the joint family decision. Accordingly, the Supreme Court dismissed the Unions of India's appeal along with the cost. Legal principle established. Point 1. If the decree is passed in favor of the joint family and their property is undivided, then an appeal against the deceased successor cannot be maintained. Point 2. The affairs of a joint Hindu family may only be managed by those who are members of the joint family and have the authority to represent it. Please watch full video, share and subscribe to the channel. Thank you.